before we even hear the judge speak, let's pause for a second, because what you're about to watch is not just one eviction case. It's actually two very different landlord-tenant battles, both unfolding in real time, both revealing how unforgiving courtroom procedure can be when even small details are missed. In the first case, we're dealing with thousands of dollars in unpaid rent, repeated bounced checks, and a tenant who never even shows up to defend herself. On paper, that sounds like an open and shut eviction. But as you'll see, court isn't just about who's right. It's about what you can prove and how you prove it. One missing document can stop everything cold. Then, in the second case, the numbers are smaller, just $1,000 in back rent. But the confusion is much bigger. Watch closely as the judge walks the plaintiff step by step through a sworn affidavit, repeatedly warning him about federal penalties if he gets it wrong. This is where nerves, paperwork, and legal responsibility collide. So here's the question you should keep in mind as we go forward. If you were in their position, would you know what the court expects from you? Because today's cases make one thing very clear. The law doesn't care how long you've been a landlord. It cares whether you followed the rules.
We're here for an eviction suit. You indicated that the defendant in today's case, Anasia Sanders, defaulted in the terms of her lease by not paying rent. So with that being said, we're going to have you sworn in and proceed on with today's case. Raise your right hand, sir. Then nothing but the truth, so help you God.
I do.
All right. And so with that being said, just have to ask you a couple of questions before we get started.
Let's stop right here, because this is where the financial reality of eviction court often surprises people. The landlord has just laid out a pattern of non-payment, bounced rent checks, a bounced security deposit, and months of unpaid rent. But what really matters is how the court categorizes that money. Eviction court is not a catch-all debt collection forum. The judge isn't here to punish bad behavior or recover every dollar lost. The court's authority is narrow: back rent and possession of the property. That's it. NSF fees, late fees, and security deposits, those live in a separate legal lane. And that's why, even though the landlord feels wronged, understandably, the judge is already steering the case toward what the court can legally award. This distinction is crucial, and many landlords don't learn it until they're standing right where this man is now.
Do you have a contract with regular housing authority whereas they subsidize a portion of the tenant's rent for this property?
No.
Okay. And this property is there anyone residing in this property that receives any form of housing?
No.
Okay. And so with that being said, sir, I'm going to give you the opportunity to proceed with the case against the defendant. Go ahead.
Yes, sir. So, Judge, I have been working with Anasia, or I should say Miss Sanders, for the last several weeks. But bottom line is, she moved in September 2025. With the exception of 1 month of rent in October, all of her checks have come back returned with non-sufficient funds. So her security deposit bounced, came back as non-sufficient funds. Her rent for September, her rent for November came back non-sufficient funds, and she's yet to pay anything for the month of December. So she's had multiple NSF notices from the bank. I've talked to her. She said her sister was stealing from her and she needed to pursue legal charges. She was going to have a detective, but all of that aside, I haven't heard from her, and rent continues to be not paid.
Okay. Looking at the documents you filed with the court as well as your sworn complaint, you stated that the notice to vacate was served to the defendant by posting it on the inside of the main door entry. Is that right?
That's correct.
And that was done according to your notice on December 11th, 2025. Is that right, sir?
That's correct.
All right, now so let's look at the lease. This property is within the LLC. Are you a managing member of the LLC or the owner of the LLC?
This exchange right here is a perfect example of the emotional disconnect between fairness and legality. The landlord is asking a very human question. Why should I eat the cost of bounced checks and bank fees when the tenant caused them? But eviction court doesn't operate on fairness. It operates on jurisdiction. The judge is being firm but correct. Eviction court simply doesn't have the power to award security deposits or NSF penalties. That doesn't mean the landlord is out of options. It means he's in the wrong courtroom for those claims. This is a moment a lot of viewers can probably relate to. How many people assume court is court, and that once you're there, everything gets resolved? In reality, choosing the right legal path is just as important as having the right facts.
That's correct. I am the sole member of the LLC.
Okay, that sounds good. And looking at your lease here, let's take a look at, they got the terms, automatic renewal. And so the monthly rent for this property is what you were charging, $1,800 per month. Is that right?
That's correct.
And you're saying she owes for 3 months back rent? Is that approximate?
That's correct. So the unpaid rent, late fees, NSF fees, along with the unpaid security deposit.
The only thing that the courts can award is just back rent. All of the other fees, NSF fees, the late fees and things like that, the courts cannot award those. The only thing that we could actually award are attorney's fees and back rent. And so if we're looking at back rent and court costs, you got 1,800 times 3. So in total, she owes $5,400 in back rent. That's for the months. Let's just say that that's going to be for October, November, December. The payment that she made to you in October should have been credited for September is the way I see it.
So what about, Judge Lee, with all due respect, what about the security deposit she had to pay?
That is not covered with regards to eviction suits.
Okay, so do I need to pursue civil? Like, how do I proceed with that? Because I don't feel like it's fair for her to just basically pay unpaid rent and all of the late fees that I've incurred relative to the NSF fees from the bank. That shouldn't be on me. So is that just a civil matter?
That is a question. It is considered a civil matter. I encourage you to get with your attorney. It looks like you have a good relationship with John Malone.
Noted, noted.
He could advise you on what steps you can take to recoup any of the losses outside of what is rendered as judgment in an eviction suit. Okay.
That's noted.
All right. And so let's take a look. Do you keep like a running ledger or anything like that that shows any payments or credits and anything like that? Do you keep that?
For this particular tenant, I can certainly create one. I thought I submitted to the court where every one of her checks have been returned. Is that not included in the documents?
Let me take a look. I didn't see anything. So I'm gonna tell you what I have. I do have your petition, which is a sworn complaint. I have the Civil Service Relief Act affidavit. Okay, you did provide me with, this is I see here. It's
And that's for every payment that she submitted that was returned from Central National Bank.
and these are the ones that were returned. So
Correct.
the one she did, one of them went through, but these others did.
That's correct.
Okay, I have that. Okay.
Okay.
So all right, so I do have the notice to vacate. And so there's one other document that.
Now we've reached the most important procedural issue in this entire first case, and it has nothing to do with rent. This is about the Service Members Civil Relief Act, a federal law designed to protect active duty military members from default judgments. Here's the key point. When a defendant doesn't show up, the court must be absolutely certain they are not on active military duty. That's why the judge isn't satisfied with assumptions, job titles, or applications. He needs verifiable proof from the federal database. And notice how serious the judge is here. He explicitly warns about criminal penalties for false affidavits. This isn't paperwork trivia. This is legal exposure for the plaintiff. The court pauses the eviction not because the landlord is wrong, but because the process must be airtight.
That we're missing in with regards to civil suits. Are you familiar with the Civil Service Relief Act?
I thought I completed that when I submitted it to the clerk. That was one of the first documents on the front. That wasn't, yeah, that.
So you did fill out the affidavit. You did fill out the affidavit.
Okay.
But if you look at the top of it, so what usually happens is whenever the defendant doesn't show up in court, you're swearing on this affidavit that they're not enlisted in the military, but also there's a website that you could navigate to. There's a link right there on that document. It says in that last paragraph, to obtain certificate of service of non-service under the Civil Service Relief Act affidavit, you may access the public website at that particular site. This website will provide the current active military status of the individual. So not only are you swearing to the court that the defendant is not actively enlisted in the military, but you also should provide some additional proof to support your sworn statement. And here's the reason why I require this right here. It's to make sure that, one, we're not putting a judgment against someone that is actively enlisted in the military. And two, there's some protections in there for you, because at the bottom of it, it does say that the penalty for making or using false affidavit, a person who makes or uses an affidavit knowing it to be false shall be fined as provided in Title 18 of the U.S. States Code or in prison. So one thing that we have to have is not only the affidavit, but also proof that they're not actively enlisted in the military. And that's where that database would come into effect. And the government, it's a free site. The government put this site in effect to give the courts additional proof that the defendant is not enlisted in the military, but also protections for the plaintiff, so that you can have comfort of knowing that you won't be sued or face any, not sued, but fined or face any type of jail time in the event that this person is actively enlisted in the military. So that's the reason why I was asked, are you familiar with the act?
No, I actually, if I would have, on her rental application, she is an educator. She's a coach at Hillsborough High School. She did not list any type of service or being in the military on that said application. So I can certainly go and do what you asked me to do, but that would have certainly been called out in the application that she completed.
Did she give you a copy of a check stub or anything just to verify
She
that?
gave, well, and with all due respect, I'm not sure what she provided me was legitimate after all of this. It feels like she's been here before. She knew exactly how much time she needed, what have you. And I don't want to, debate without her being present. But I do have proof that she is, and she's 23-year-old. She's 23 years old, Hillsborough, ISD. Like, I have that information per her application. I know she's not in the military, Judge.
So you put it, she put it on the application, but she didn't show you an actual badge or
Yeah,
check stub.
so she showed me that. It's just, she said she was going to be also working at, I believe, State Farm, and she showed me an offer letter. I'm not sure all of that is true. She also said, and again, I it's neither here nor there. If we could just proceed, I can get you whatever you need to prove that she's not in the military. We'll be fine.
So this is what I'm going to need. And again, this is a practice, because this is my first time seeing you in my court. I don't know if you've filed in other courts, but it's a practice that I want to get you accustomed to. Which
Well,
is
hopefully
going
I don't have to see you again. I've been doing this for 30 years, and this is my second eviction that I've had to go through.
And just like that, we shift into a completely different eviction case. But you'll notice a familiar theme almost immediately. This time, the landlord is claiming $1,000 in unpaid rent, a much smaller amount, yet the procedural hurdles are just as high. The judge's questions come fast. Is the tenant still there? Was notice properly given? Do you have the lease? When was the last payment made? These aren't casual questions. They're checkpoints. Miss one, and the entire case can stall or collapse. What's striking here is how quickly confusion creeps in. Dates don't line up cleanly. Communication stopped months ago, and now the same issue we just saw, proof of non-military status, is about to take center stage again.
So
Yes,
hopefully
sir.
we won't have this problem again. But duly noted, I'll get you whatever you need to satisfy the court, and we'll proceed accordingly.
Okay, so I'm going to need that. I'm going to need you to go onto their website, put in her credentials, which is her name and her date of birth, and then at that time it's going to print out a database. And on that database, it will confirm whether or not the defendant is actively enlisted in the military. I need you to go into that website, print it out, and scan it in and email it or fax it over to the court. Once I have that, then I could sign off on the judgment. Okay.
Very well. Duly noted.
All right. With that being said, the case is going to be pending on my desk. About how long you think it'll take you to navigate to
Well,
that site?
so will the clerk help me with that website? Because I don't, can that be emailed to me so I know exactly where to go, and I can send that over today? Yeah, I need to get this resolved today.
Okay, you can contact the court and they can email you the Relief Act
Okay.
affidavit. And then on that affidavit, it has the link. But that's pretty much, we can do that for you. But just
Perfect.
contact the court and the court clerk will, see what she can do as far as, getting you the information you need to go into the website, okay?
Okay, farewell.
All right, with that being said, God bless you, may be excused.
We have an eviction suit today, Mr. Motor. You're the plaintiff. You filed this suit against defendant Sandra McCulloch. At the time you filed the case, you said that the defendant didn't pay her rent. She owes you $1,000 back rent. So with that being said, the bailiff is going to swear you in and then proceed on.
You can raise your right hand for me, please. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
All right. So, Mr. Motor, let me just ask a couple of questions in regards to this case. Is the defendant, is she still staying there at this house?
So I know, yes.
You stated in your petition that she owes you $1,000 in back rent. What is the monthly rent that you and the tenant had agreed upon?
$1,000 a month.
You have a copy of that lease?
Yes.
Let's see the copy of that lease. You said that you mailed her a notice to vacate. Already mailed, is that right?
Yes, sir.
You just moved in
Yes, sir.
November.
Right.
So she paid, so the rent that you're asking for is for December?
Yes, sir.
So she moved in November, paid the deposit in the rent. Didn't pay her rent for December. When was the last time you talked to her?
November, when she paid the rent. That's last time I talked with her.
Appreciate that, Mr. Moore. About how old is this woman? Jen, how old is she?
Oh, no, she's maybe about 30 years old, maybe.
Born in 72, according to what she put down.
Oh, okay.
So that puts her a little over 50.
Oh, 50, okay.
Does she work?
Yes.
Where's she work at?
She work at the VA.
Did you get a copy of her license or anything, whatever you let her move in?
I get a copy of what?
Driver's license.
No, I get no copy of. She gave me her driver's license number and everything. It's on that. A driver's license number, that's social security number. It's on that.
How can you prove that she's not in the military, Mr. Moore? You didn't even fill this out. You didn't even fill it out, Mr. Moore. Yeah, you got to fill that out. That's your sworn affidavit. Or your military status.
I really good. Yeah.
You got to check one of those boxes, Mr. Moore. Yeah.
This moment is tense, and for good reason. The judge isn't being difficult, he's being protective of the process. A sworn affidavit isn't just a form, it's a legal statement made under penalty of law. The plaintiff is clearly uncomfortable, unsure how to phrase his reasoning, unsure what's enough, and the judge refuses to put words in his mouth. Why? Because if the information is false, even unintentionally, the consequences fall on the person who signed it, not the court. This is where a lot of landlords realize they're in deeper waters than expected. Knowing your tenant doesn't feel military isn't evidence. The court needs documented, objective proof, and without it, everything slows down.
So you check 2 of these boxes. Check 2, you only need to check 1. So okay, so you still not filling this out. I really wish we could get somebody to help you with this, but you still not filling this out. I highlighted the areas that you need to complete. The top one, what is it say? The first highlighted area, what is the thing?
Okay, the planner, I'm the planner.
Now,
Okay,
that second one, the second highlighted one, read that before it's highlighted. What does that say? You check that box.
okay. No defendant in this case is on or active duty in the U.S. military, Army, Navy, Air Force, Marine, or Coast Guard. Okay, well, I checked that.
Okay, there's more to it.
Uh,
What else does it say, Mr. Miller?
that is, in fact, in fact, on this base, my collusions are as follows. What's
So-
that?
The one thing that you check the box that said that she's not in the military, but you have to provide some facts
Okay,
to support that statement. Do you remember filling out, going onto the computer and printing out the database that shows whenever people are not in the military? You've done that in the past.
yeah,
You got to go on the computer, go to the library and do it.
uh-huh. Oh,
To put down why you feel like she's not in the military. Just write that down. Write down why you feel like she's not in the military. And in that highlighted area. In your own words.
yeah, oh, yeah.
See what you got.
Well, I don't know.
She's too old.
Yeah. Well, I don't know what that's to put.
Okay. All right. And you did look at a driver's license, right?
Yes,
You saw her correct date of birth.
yes,
Okay. Okay. All right.
What else got to put down there other than she's too old? What else?
This is your sworn affidavit.
Yeah, yeah.
So I can only go by what you're swearing to.
Yeah, but I just asked you a question.
I can't tell you.
Oh, okay.
Because the reason why I can't tell you is because this is what you're swearing to.
Right,
And if you lied on this, and if she is in the military, then you can face federal charges.
Yeah.
Okay? So I can't tell you, but damn.
Oh no, I wouldn't ask you about what that. I said, well, I guess maybe in the director, I'm just asking what else could I put down other than that, I guess,
Okay, I wish I could tell you.
Oh, okay.
Now, one thing I can tell you is that if you have her date of birth if you have her date of birth, you can go on to the Civil Service Relief Act's website and you can print out a database, and the database would be able to confirm if she's in the military or not.
Okay.
That's one thing, and they have that, the website on this piece of paper.
Right.
And you've done that in the past.
Yeah.
You went to the library and put in their information, and then it printed out a little database that showed whether or not that person is in the military or not.
Okay.
And that's what the government, that's the resource that the government gives to you, a plaintiff.
This is one of the most educational moments in the entire video. The judge isn't just ruling, he's coaching. He's telling the plaintiff exactly how to protect himself, use the federal database, print the confirmation, or hire professional help. The underlying message is clear. Eviction cases might look simple, but they are procedurally unforgiving. One checked box without proof can expose someone to fines or jail time, and the court will not rescue you from your own sworn statements. If you're watching this as a landlord, this should raise a serious question. Are you prepared to handle these filings on your own, or are you assuming experience will cover legal precision?
To support your case, if the defendant does not show up for in regards to military status. So, but outside of that, nothing that I can really tell you, because it's your sworn statement. Again, if it says on here that, penalty for making a false affidavit, a person who makes or uses an affidavit knowing it to be false shall be fined as provided in Title 18 of the United States Code, or imprisoned for no more than 1 year or both. And so I wish I can't really just tell you anything. It's, it's what you're swearing to me, and, pretty much what you're swearing to me, that she's not in the military, and this is the proof that I'm using to support that she's not in the military. So that's kind of how it goes. So it's all on you. You want to protect yourself. I would strongly encourage you to either get a little savvy with the computer again, because you've done it in the past, and start printing out those databases, or hire a professional, which is a real estate agent, to assist you with your property, so you don't have to worry about any type of fines or imprisonment. Okay. All right, Mr. Moden, we're going to rule in your favor. Possession of the property in question, 704 Killam, Waco, Texas, 76704, as well as back rent for the month of December. That is $1,000. The defendant's appeal bond is going to be $2,000, and she has 6 days from today's date to appeal. If she does not appeal on or before that 6th day, then on that 7th day, you can come back and file for your writ of possession. Okay? All right. Any questions, Mr. Moden?
No.
All right. And just to confirm, she's not on any housing, is she?
No.
Okay. All right. We'll get that judgment mailed to you. Unless if you want to wait in the lobby, I can have the court clerk, print it out, get it signed for you. If you want to wait about 10 minutes, or else I can get it mailed to you. What would you like to do?
Well, I can wait, or you can mail it, either one.
You just tell me.
Okay, but I can wait.
You want to wait? Okay,
Yeah.
we'll just wait in the lobby. We'll get it printed out. Get it to you, okay?
Okay.
All right. Take care of yourself, Mr. Bowles. Happy New Year to you.
So let's bring this all together. In the second case, despite the paperwork struggle, the court ultimately rules in favor of the landlord, granting possession of the property and awarding $1,000 in back rent, with a clear appeal window and bond amount set for the tenant. The legal process works, but only after careful compliance. Across both cases, the lesson is unmistakable. Eviction court is not about emotion, frustration, or even long-term experience. It's about documents, jurisdiction, and sworn proof. Miss one requirement and even a strong case can grind to a halt. Now, we want to hear from you. Do you think eviction court places too much burden on landlords, or is this level of protection necessary? Would you have handled these cases differently? If you found this case as shocking and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns just like this one.